Alright, this is Baker versus Carr 1963 SCOTUS case study. The background of this case is that plaintiff Charles Baker lived in Tennessee and had previously served as the mayor of Millington. The Tennessee Constitution said that the legislative districts must be redrawn every 10 years after the census, and Baker complained that the districts had not been redrawn since 1901, giving more power to rural districts. And keep in mind that this case was in 1964. The defendant, or who was suing, was Joe Carr, who was the Secretary of State for Tennessee. And Joe Carr was sued as ex officio, meaning he was responsible for the conduct in elections in the state, but he did not personally draw the district lines. Two of the issues involved were: one, did Baker's County receive equal protection under the laws guaranteed by the Fourth Amendment? And do courts have the authority to rule on legislative apportionment through the Equal Protection Clause? So possible outcomes / decisions of the court were that the court rules that the issue of legislative districting was a question of justice and not politics, and therefore the court could get involved, leading to redistricting, or the court rules that the issue is a question of politics and they shouldn't get involved. So SCOTUS ruled in a 6-2 decision that the issue of legislative districting is not a political decision, but a decision of justice, and that the courts could get involved with districting. Their reason is that the majority opinion was written by Justice Brennan, that states these plaintiffs and others similarly situated are denied the equal protection of the laws accorded them by the 14th Amendment to the Constitution of the United States by virtue of the debasement of their votes. And then he stated that it made it clear that its dismissal reflected a view, not of doubt, that violation of constitutional rights was alleged, but of a court's impotence to correct that violation. So summed up, that he was saying that courts should have the power to rule on their redistricting, and people should have a fair vote under the 14th Amendment. The dissenting opinion was written by Justice Harlan, and he was joined by Justice Frankfurter, that states the issue here relates not to a method of state electoral apportionment by which seats in the federal House of Representatives are allocated, but solely to the right of a state to fix the basis of representation in its own legislature. So basically, he's saying that it's up to the courts to fix, or it's up to the state to fix the apportionment, not the courts. And he also wrote, I can find nothing in the Equal Protection Clause or elsewhere in the federal Constitution which expressly or impliedly supports this view that state legislators must be so structured as to reflect with approximate equality the voice of every voter. He's basically saying that not every single vote has to be 100% equal under the Equal Protection Clause. The significance of this ruling was that this case allowed underrepresented voters to have their district lines redrawn, allowing there to be a fair vote. This also allowed for every other state to be reapportioned, giving a fair vote to every citizen around the country. This shift in districts caused political power in most state legislatures to shift from rural to urban areas, and it expanded the power of the courts to rule on legislative districting. A similar case was Reynolds versus Sims, and it was a very similar case in Alabama having to do with the apportionment of the state legislature. And Baker versus Carr was cited in this case, and it was used. It was ruled on as a precedent. And once again, Brennan and Harlan were both on opposite sides of the ruling, but this time Harlan was the only justice that ruled against him. And again, the court ruled in favor of allowing the court to intervene and help with the apportionment of the districts. Another similar case was Colgrove v. Green. This case was actually around 20 years prior to Baker versus Carr, and it was once again arguing the constitutionality of unfair district lines. And unlike the other cases 20 years later, this case ruled in favor of the defendant, stating that the district lines were constitutional and it was up to the states to keep it that way. How to remember this case. You can think of this case as an actual baker versus a car manufacturer. The baker wants all his cookies to be the same size, while car manufacturers make all different types of cars, like trucks and sports cars and hatchbacks. And it's just like that baker wanted all votes to be counted equal, and Carr in the state of Tennessee wanted the lines to be unfair in their favor. And those are my cited sources.